Good evening, one and all. I, Vishweshwar Pathadi, High Court Bar Association, pleased to welcome you all for the third lecture of lecture series program organized by Advocates Association of Bombay High Court Bench at Aurangabad. We are glad to have with us Senior Advocate Shri.S.B.deshpande sir as our speaker of today's lecture. As a token of appreciation and gratitude, I now request Mr. Avinash Borulkar sir, President of our association, to felicitate our today's speaker, Senior Advocate Shri.S.B.deshpande sir. Thank you, sir. Moving forward with the program, I call upon Mr. Ravindra Gore sir, Secretary, to give brief introduction and intent for conducting the lecture series.
Our Chief Speaker, Senior Advocate Shri S.B.deshpande sir, our President, Mr. Avinash Borulkar, Vice President, Mr. Shrikant Kavde, Vice President Lady, Mrs. Shilpa Avchar Sherkhane, all my committee members and respected advocates who are present for today's lecture series. In fact, a journey of lawyer starts from when he became law student. Then next stage would be law intern. And then real test of any lawyer, he became junior. And then comes when he become most senior junior amongst his office, his chamber. And then next step is he became independent lawyer. And then next stage, middle-aged lawyer. And then lawyer who is having practiced more than 30 years, 40 years. So in this journey of lawyer, one thing is constant. You have to keep practicing, you have to keep learning. Therefore, there is saying, lawyers and doctors are not perfect because they are always practicing. So in our profession, learning and practicing, these two things are very important. Therefore, be it Supreme Court, be it High Court, be it District Court, every bar is very keen to keep this momentum, this learning process continue. And therefore, lecture series is organized by every bar. And our bar is also arranging this lecture series since long back. Now this year, we have just keeping this momentum with lecture series. We separated this lecture series in three parts. First is Know Thy Judge. In this segment, Honorable Lordship will interact with us and his journey from bar to bench. They will explain to us. And therefore, this will be motivational factor, inspirational factor for amongst many junior lawyers to know the judge, how his journey from bench, from bar to bench. Now, in this segment, Honorable Justice Shri R.V. Guge has delivered first lecture. Now, moving forward, the next segment is that this lecture series, the proper lecture. In this segment, we are arranging the lecture of senior advocates. Earlier, Mr. V.D. Sapka has delivered lecture on drafting and pleading. Now, this second lecture, which is going to be delivered by our senior advocate, Mr. S.B.deshpande. Now, third part, that is very interesting part, study circle. We are working on that aspect, study circle, and I hope that this study circle would happen in January. So this lecture series is very important, and we are very happy that we are receiving the support from junior lawyers for this lecture series. Now, I will not become hurdle between the main speaker and audience. Now, while signing off, I would request every members to attend to support us for lecture series. Thank you.
Thank you, sir. Today, we have with us Senior Advocate Sanjeev Bhaskar Rao Deshpande sir as our speaker. Sir has completed his BSL LLB from Manikchand Pahade Law College, Chhatrapati Sambhajinagar. After completion of law degree, sir enrolled with Bar Council of Maharashtra and Goa in 1989. Sir has conducted various civil, criminal and constitutional matters. Senior Advocate S.B.deshpande sir has also worked as the Assistant Solicitor General of India at High Court Bench at Aurangabad from period of 17 July 2014 to 16th of July 2020. Sir has worked as advocate for various panel such as Pharmacy Council of India, Accountant General, University Grant Commission, BSNL, Municipal Corporation and Jilla Parishad of Chhatrapati Sambhajinagar. I now request our today's speaker, Senior Advocate Shri.S.B.deshpande sir, to share his insight on Shakespeare on law and lawyers. Please, sir.
Honorable President of High Court Bar Association, Honorable Secretary of the Bar Association, Honorable Vice President, and my dear friends. When few days ago, Secretary Advocate Gore came to me and directed or ordered me to deliver a lecture, I was in two minds about this subject. I was not sure which subject to choose. We may call it my dilemma was of the nature of to be or not to be. It is not that I don't want to speak, but what should be the subject? Few years ago, I was introduced this particular subject when I read 2-3 books on this subject, and then number of articles were also read by me. So I thought that it is just and necessary to throw light on this particular aspect, and therefore this topic is chosen. I must start with certain disclaimers. Number one, I am aware that I am neither expert on Shakespeare nor expert in law. My endeavor is to introduce all of you to this wonderful topic. So, whatever I am submitting before all of you may not be considered as an authoritative pronouncement on the subject, but rather it is an introduction to this subject. Bearing in mind all these limitations, I am now starting my main topic. I will also be requesting you that I will be covering 4 to 5 plays or acts by Shakespeare. It will not be possible to even touch so many acts, because Shakespeare has written so much in his life of 52 years only that it is impossible to even touch many of those plays in one single lecture. Now, as far as law and literature is concerned, every one of us is aware that day in and day out we are concerned with words, words and words. We are concerned with commas, we are concerned with exclamatory marks and whatnot. Therefore, what is necessary for us are the letters. And if we are well versed in letters, then definitely we may excel. Otherwise, if we are searching for words or unable to put forth our views, then it will be difficult for us to be successful as a lawyer. And it is always said that there is a connection between the life of the mind and life of the law. The word is that life of the mind, and that is literature. And life of the law means the law. When some scholars categorize laws, two broad categories are made. One is law as humanism, and another is law as science. Law as science means that the votaries of this school of thought, they say that law should be like arithmetic, 1 plus 1, 2, or it should be like logic, that a particular logical conclusion must be arrived at in given set of facts and circumstances on the basis of certain submissions, etc. On the contrary, the law of humanism is something different. It is a synergy of law and literature. Law is romantic in ideology, more like a poetry. An act of persuasion is involved therein. It's a cultural practice of justification using language. Why justification using language? Because there are ways and means adopted by every person to settle the dispute. We want to settle or justify our cause by using language. And therefore, it may be called a ritual, it may be called a drama, legitimizing ideology. So when we consider all these aspects, we will find that one very renowned scholar by name Richard Wisberg has coined word literary lawyer. And he said that by literary lawyer I mean it as a badge of honor. Literature has much to teach about law. He was of the view. It provides unique insight into the underpinnings of law. And all these views are expressed by Wisberg in his book called as Poetics, wherein this concept of literary jurisprudence is developed. And what he says is that literature teaches about ethics in law. You may get teaching about law regarding the sections in law school. Even these topics may be brushed upon. But what literature teaches, it gives you ethical insight into the development and application of law. That is one of the most important aspects. And it demonstrates the great extent to which law is intertwined with language. Now this is also important because law means only the words and language. We are using language, we are interpreting language, and therefore when the literature intertwines it with law, then it becomes really very great thing. It is said that greater ethical awareness in law is done by this literary lawyer. And literature can make lawyers and judges more empathic, aware of cultural variety and nuances of individual motivation. The poetic method adopted in literature provokes us to highlight the linguistic, the sensory aspect of every part of our craft. Law is utterly dependent on language. Literature heightens our understanding of language and symbols and combination. So what is the key to law? Is the interpretation. The techniques used to interpret literature may be used for even interpreting law also. And therefore, another scholar by name Posner has said that well-educated lawyers should have some acquaintance with recent or current controversies in literary theory and their potential bearing on legal interpretations. Lawyer may be professionally dependent upon a fusion of law and literature. So with this background, now let us go to the man we are now dealing with, that is Shakespeare. In his life of 52 years, he penned nearly 39 plays, 154 sonnets, and 3 long narrative poems. One of the author on this particular topic, Shakespeare and law, Constantine, he described Shakespeare as the greatest law school. And it is said that great art is often inspired by a passion of justice. This is replete in every play wherein Shakespeare dealt with some legal aspect. Some statisticians say that 2/3 plays of Shakespeare are having trials or law subject dealt with. So this is the importance Shakespeare has given to law subject. His works made comment on race relations, autonomy, privacy, natural law, censorship, libel, inheritance, sovereignty, immunity and delegation. One very famous author, Shelley, wrote in a defense of poetry that poets are the unacknowledged legislatures of the world. A very meaningful verse by Shelley. What he says is that poets are legislators, though they may not be acknowledged by people like they do for lawmakers, MPs and MLAs, etc. But by their vision, by their experience, and by their exposition of the particular subject, they touch the raw nerves of the subject. They deal the matter in a very different manner, which naturally results in the enactment on the particular aspect. And therefore, in this background, when we go to some of the most important legal plays as it described of Shakespeare, the first play is Merchant of Venice. And therein, there are 2-3 characters. One is Shylock, one is Antonio, one is Portia. As far as Shylock is concerned, if you will go through law journals, you will find that there are thousands of cases wherein this name Shylock is mentioned. Shylock is referred to as a very harassing moneylender, and in that context, Shylock is always used or derided also. So the story is also very interesting. Shylock is a moneylender, and Antonio was in need of money to help one of the friend. And some of his ships were coming from abroad. He was requested by a friend for loaning some amount. He goes to Shylock. Shylock says that, okay, I will lend you money, but we will have one agreement, we will have one contract. And then contract was signed. And what are the conditions in the contract? The condition in the contract was that in case of default, a pound of flesh near the heart of Antonio will be taken away, and the Shylock will be entitled for that portion. Unfortunately, there is default, and matter is taken up in court. During trial, the words are plaintiff and defendant, we may say like that. Plaintiff and defendant, plaintiff said that I gave him money, he needs to return that money. Then defendant said that yes, I committed default, but for these reasons I committed default. And he pleads for mercy and says that I am ready to pay many times the amount that was due from me. and the matter should end. The Portia, who was there, she also tried to convince Shylock to take away the money and then the matter should be settled. She said that you will get many times more the amount you have lent. Shylock was not ready. He said that he wants the clause of the contract to be implemented entirely. So Portia was really very brilliant, and then she decided and said that, okay, you will get the pound of flesh, no doubt. But mind well that while taking away the pound of flesh, there should not be drop of a single drop of blood should be there. And if one drop of blood falls on the ground, then you will be dealt with severely. When Shylock also tried to reason on this aspect and said that no, it can't be done because my contract is only regarding this particular portion. And she said that, okay, but how now to implement this particular contract? There is no mention of spilling of blood, drawing of blood. And when the ultimate result was that it was held that the contract was not enforceable and Shylock was penalized, some part of his property was given to this Antonio and some part was given in will, etc. That's a different story. The point is that nearly 500 years ago, this type of case was dealt with by Shakespeare, wherein the contract was interpreted and a very ingenious method was devised, and it was said that it can't be done. And if we see the word, the situation was that Portia asked him that if you want to extract flesh, then you must keep a doctor ready for taking care of the blood. And then Shylock said that it is not mentioned in the bond. Contract says pound of flesh and not blood. Faced with such hyper-technicality, and the judge then said that this contract is it cannot be enforced. This is a very fine example wherein judicial discretion is exercised, wherein instead of technicality in the contract, the spirit of law was tried to be upheld. And if we see the narrations in the play, the quality of mercy, etc., was also discussed in these things. This Shylock, as I said earlier, is mentioned in many, many matters. And in recently, this particular merchant in Venice, another sentence was quoted by Honorable Supreme Court of India in the matter of Manoj Kumar Soni versus State of MP, reported in AR 2023, Supreme Court 385. And in para 24, it is quoted, you speak on infinite deal of nothing. Act 1, Scene 1. The Honorable Court was discussing about the relevancy of the testimony of a particular witness and discussing main 3 also. The meaning is that whatever the witness has said is absolutely irrelevant, and for driving this particular point, the Honorable Supreme Court has quoted Shakespeare's line from this merchant in Venice. Then another very important play is Measure for Measure, and this is a very complex play. wherein there is a duke who is not happy with the manner he is conducting the affairs of the state. He decides to delegate the affairs to his colleague and then Angelo. And then he goes away. Angelo strictly enforces law. Then as compared to Duke's regime, law and order is restored. However, there were very strange rules. There was one person who was in relationship and had actually decided to marry a particular girl. However, prior to marriage, she got pregnant. And when this fact came to the notice of Angelo, he called him and said that you have committed an offense and you are liable to be dealt with by death for penalty, as penalty. Therein, another character comes into play, that is Isabella, and she pleads that not to execute this particular decision. Like other people, the Mr. Angelio had also other vices, and he demands physical relationship with this lady, who was not at all ready to do that, but reluctantly agrees to do so. And in the night, one lady was sent, was not Isabella. Angelo thinks that it is Isabella. Still after this episode, he decides to execute the death penalty. And therein, it so happens that in prison, one prisoner had died. His head was cut and sent to Angelo, and he was informed that now the death penalty is executed. In the meantime, Duke returns and he sees the injustice that is done. He was aware that the convict was not put to death. Then, with the help of Isabella, all these things come to an end. The point is that in this play, there are many lessons for a lawyer. The lesson number one is regarding privacy. Whether law should intrude into the personal affairs of a person to the extent of even going into the bedroom of a person who may not be married to that particular lady. Another question is that how much law should be used to enforce morals? Is it the duty of law to enforce morality, or law should set some rules which may not be moral in the eyes of a particular generation, but is an evolving process. For example, it cannot, now in the modern age, nobody will say that if a person is willing to marry a lady and in their relationship, if the lady gets pregnant, by no stretch of imagination in the modern age it will be called as an offense. Then there is also a very important principle involved in this matter, and I had fortune to argue on this particular word, that is dissuasive, which means that if a law is in force, but it is not at all implemented for a number of years, then whether such law can be enforced or not, in that case, there was no precedent of having executed a person for having impregnated his paramour or fiancée like that. So that was also the question which was raised. And in that regard, in regard to this dissuaditude, it is said that in this measure for measure, the law hath not been dead, though it had slept, now it is awake. It is said that yes, it was not used, but now we are using it, maybe after a long slumber, and therefore this needs to be done like that. And in the same breath, a very useful couplet is quoted in this measure for measure, and it is that laws for all fault, but fault so countenance that the strong statutes stand like the forfeits in a barber shop, as much in mock as a mare. And therefore, the question of another important question from our point of view is that whether punishment should be deterrent or not. For trifle offences, for small offences, whether death penalty should be inflicted or not. That is also a very important question. And then the question is that whether mercy should be shown in such matter or not. Therein also, Shakespeare quotes very eloquently, and the quote is that, Good my lord, bethink you, who is that had died for his offence? There are many have committed, but they were not punished. And therefore, this should not have been done. That is the message that is given. As far as mercy is concerned, it is also always considered to be the hallmark of judicial system. And Shakespeare writes, and I quote, how would you be if he which is the top of judgment should but judge you as you are? Oh, think on that, and mercy then will and mercy then will breathe within your lips, like man new made. How beautifully mercy is defined in this couplet. Words used are, mercy then will breathe within your lips. Mercy, which is the most important, which is one of the most important virtue, will be then come out of your lips. And if you show mercy, then obviously justice must prevail. This play is also an example of abuse of power. Angelino was given power by Duke, he abused it. Then it is also concerning sexual harassment and delegation also. Most importantly, this play is a lesson on how to control human behavior effectively by means of rules. Blending of law and discretion, and therefore one of the couplet or one of the sentence in this play is that we must not make scarecrow of the law. Law should be there to help the person and should be handy for the person who allegedly committed any offense. Then when we go to Hamlet, we'll find that Hamlet is also considered to be one of the best plays of Shakespeare. Hamlet may be considered to be another legal play, and therein the story is that ghost of Hamlet's father is coming into his dreams and saying to take and ordaining him to take revenge of his murder by his uncle. Then Hamlet decides to do so, and then the story then goes on and goes on. I will cut short because it may take much time to deal with the matter. The thing is that in this play, there is an instance wherein Hamlet is, along with gravedigger, is in a graveyard. And therein they dug certain things. A skull appears. There he says, is it skull of a lawyer? And then he says that how he must have obtained the property, and then how he must have ruled and had advocated or championed the cause of the litigant, etc. In this play, Hamlet illustrates how a law can benefit society by properly and usefully taming, channeling passion for revenge. Everybody may be having these savage feelings of revenge, but then this must be tamed. This play is also important for two more important legal concepts. Therein it is said, prior to that I will read from the couplet of skull of a lawyer. There is another. Why might not that be the skull of a lawyer? Where be his quiddies, now his quillers, his cases, his tenures and his tricks? Why does he suffer this rude knave? How to knock him about the score with a dirty shovel, and will not tell him of his action of battery? Therein, we may say that Shakespeare was not having very high opinion of advocate. That I will deal in the last segment of my speech. Will deal with that aspect also. But the thing is that lawyers are mentioned time and again by Shakespeare. One of the important defenses we always take in criminal trial is the plea of insanity. Even recently in 2023 5 SCC 673, the Honorable Supreme Court Division Bench consisting of Justice Sundaresh and Justice Gavai, they quoted one particular paragraph from Hamlet, wherein this plea of insanity is taken 500 years ago, more than 500 years ago. And this is from Hamlet Act number 5, scene number 2, line number 245. Lordships have quoted, Lordship has said, and I quote, wasn't Hamlet wronged, Laertes? Never Hamlet. If Hamlet from himself be taken away, and then he is not himself, does wrong Laertes, then Hamlet does it not. Who does it then? His madness, if it be so. Hamlet is of the faction that is wrong. His madness is poor Hamlet's enemy. So what in substance he wants to convey is that Hamlet has not committed anything wrong. It is the madness that had grieved Hamlet that has committed the offense of murdering his uncle. And it is the faction of Hamlet that has wronged the another person and not Hamlet. This is exactly what we call as plea of insanity. And see, what I said earlier, poets are legislatures. The poet saw many centuries future and had envisaged that a plea of insanity can also be taken And in that particular matter, it was taken. When it is said that there are many defenses, the Honorable Supreme Court in this particular judgment, and I quote para 1 itself, while acknowledging the hurt that he has caused to Laertes for causing death of his father, whom he murdered by way of a mistaken identity, Hamlet pleads temporary madness. While pleading so, he dissociates himself from the act as if it was done by a third person and he was made to suffer the consequences. He that pleads to treat him as a victim and not an offender. Shakespeare brings out the agony of a man having to justify his act of madness. And therefore, such illustrious and such prophetic words were used by Shakespeare. There are many quotes of Shakespeare which are always used by the Honorable Constitutional Courts. For example, in Pebam Ningal versus State of Manipur, in paragraph number 4, while discussing the aspect of personal liberty, Supreme Court quotes Shakespeare and says that man is master of his liberty. So when we analyze the preamble and when we consider liberty in modern times, we must be aware that Shakespeare, way back around 500 years ago, has considered this aspect in a very different manner. Then we are also concerned with the aspect of dying declaration day in and day out in our criminal trials. In the play of Shakespeare, King John, Act 5, Scene 4, this dying declaration concept is first time mentioned according to me, and wherein it is said that wounded Melon, finding himself disbelieved while announcing the intended treachery of the Dauphin, Louis explained. And herein the oft-quoted couplet is given: have I made hideous death within my view, retaining but a quantity of life, which bleeds away even as a form of wax, resolved from his fissure against the fire. What is the word should make me now deceive, since I must lose the use of all deceit? Why should I then be false, since it is true I must die here and live hence by truth? It is said that a person will not lie when he experiences death. And therefore, the concept of dying declaration was also considered by Shakespeare. And this is really a sort of prophetic nature of his writing. Then when we go to another important play, Julius Caesar, there are examples of oral advocacy by Brutus and Antony. After the speech of Brutus, people were were of the mood to forgive or to show mercy. But then Antony comes into play. Such was the impact of speech given by Antony that people decided to again throw away the rebels or the conspirators who were responsible for murder of Caesar. That takes me to the last play of Shakespeare, and that may be termed somewhat controversial or maybe somewhat debatable. In Henry VI, Part 2, a revolution or rebels take charge of a kingdom. Therein, the administration of the state was not done properly. The troubled reign of a weak English king was the subject matter of this particular play. When this king is overthrown, Sede, who was the leader, gives a speech and says that we want to do these things, we want to redistribute wealth, etc., etc. We want to reform the entire system like that. He was accompanied by some of his colleagues. There was a person who was called Dick the Butcher. That Dick the Butcher, after being given the sermon or lecture by the leader Sede, he immediately explains, the first thing we do, let us kill all the lawyers. So now, the question that arises before us is that, what really Shakespeare meant when he said that, let us kill all the lawyers? There are three logics or three types of theories behind this particular couplet, kill the lawyers. Why not on earth other people? Why only lawyers? Whether Shakespeare was having anti-lawyer mindset, maybe in the given case, in the given circumstances, in the prevailing situation, Shakespeare might not have good opinion, but we must mind that Shakespeare was basically a satirist. And he always used that as satire as a means of communication. One author interpreted this sentence in three manners. Firstly, he said that it may be that Shakespeare is against the lawyer, or lawyers are unnecessary, or lawyers at that point of time may be considered as parasites who are not helping cause of the people. That may be one answer. Another theory that was doing around was that Shakespeare was not against lawyers. Shakespeare was against the legal system that was prevailing then. And therefore, what he wanted to do is that he wanted to say that, and then there is another instance wherein it is said that all the other gentlemen, the chancellors, they were also called to be killed. So, whenever a violent revolution takes place, the first casualty is of reason. And therefore, Shakespeare might be contemplating a situation wherein the legal system prevailing at that point of time was not good. And therefore, word use it first thing we do. It is not that last thing, or we want to do many other things, etc. His attempt is to bring changes in legal system, and that may be the second reason for doing this. There is also third proposition, which I also support, and that is that lawyers are the last barricade between anarchy and rule of law. If lawyers are removed, then society and any state will experience anarchy. Therefore, remove them. In India, we also experience all these things. many people may take credit of saving this country from the very infamous regime of emergency. Judiciary may say so, other people may say so. But the fact is that in India there was a lawyer, we can call him Lion, who thundered in Supreme Court and said that this is fraud on the Constitution of India. And name of that lawyer is Nani Palkhiwala. It is people like Nani Palkhiwala who stood like a rock of Gibraltar between anarchy and absence of rule of law or absence of constitution and the rule of law and the rule as envisaged by Constitution of India. Present scenario in our legal system is also a very pointer to that aspect. You take any dispute in India, in our country, any dispute, you take the questions regarding liberalization policy, economic policy. Where people go? People throng courts. It may be personal matter, it may be a political matter. People believe in this system, people get relief from this system, and therefore in present scenario, lawyers are the last hope of general people to uphold the rule of law. And therefore, I am definitely of the view that Shakespeare was not anti-lawyer. What he meant is that lawyers are one of the vital functionaries in this age. And therefore, if we succeed in removing him, our designs of establishing our atrocious rule may be successful. This is the scenario. This is the challenge before all of us. And this is a gauntlet thrown upon us by the present scenario. Are we in a position to take up this gauntlet or not? I am aware that the Bar Association has not arranged its lecture simply to demonstrate that one senior counsel has read some book on this subject. That can't be the motive. The Bar Council had definite some other things in their mind. My question to this August gathering is that, are we living up to the expectation? Are we really acting as guardian of Constitution of India? Are we ably and efficiently protecting fundamental rights of our fellow citizens? Are we doing that? I will not debate much on it. Everybody must introspect on this aspect. We must prepare ourselves for the challenges thrown by the present and prepare ourselves for future challenges also. How we will prepare ourselves? We want to go into a war without the most important weapon in our armory, that is word and language. Day in and day out, our brother advocates are derided by courts for not proper drafting, for not proper language use during the course of argument or while drafting the petition. Are we in a position to live up to the expectation maybe of the constitution makers or of all these prophetic persons like Shakespeare? And therefore my humble request to all of you is that what we can take from the present lecture, Sanju Deshpande is not happy to flaunt his knowledge of Shakespeare. That is not my aim also. That is not my aim. My aim is to goad all of you to go to basics. We must do one thing, read, read and read. We must write, write and write. And if in the spelling of write, we change it slight, W-R-I-T-E, and replace it with write, R-I-G-S-T, that is the only thing which will take us to the right path. And for that purpose, my earnest plea to every one of you is that, can Shakespeare as a poet, as playwright, teach lawyers to read and write better? Can we see how Shakespeare might speak to lawyers? And here, small comma, and then word is that, at least those with ears to hear. Are we ready to hear the message of Shakespeare? And my humble request to all of you is that we must take away this message. Then only, whatever the dreams of the Constitution Constitution makers were, or whatever the prophecies were stated by people like Shakespeare, will fructify. Otherwise, the danger is that we may fall into first two categories of the kill all the lawyers exposition, which says that lawyers are but parasite. We need to dispel this notion. We need to serve this country ably, efficiently and diligently. That should be the message. Thank you very much.
Thank you, sir, for enlightening us on today's topic. As we proceeded to conclude the program, now I request Advocate Umesh Gite, member of our association, to deliver vote of thanks.
Thank you, Patadi sir. Good evening, everyone. As we came to the conclusion that enlightened guest lecture of Shri Advocate S.B.Deshpande sir, it is my privilege to deliver the vote of thanks on behalf of our managing committee. Firstly, foremost, I extend our heartfelt gratitude to our distinguished guest speaker, Senior Advocate Shri S.B.Deshpande sir, for sharing your valuable insight and expertise with us. A sincere thanks to our organizing team for meticulous planning and coordination for smooth execution of this moment. We are also grateful to our participants and attendees of this lecture. A special thanks to the technical team for ensuring all the arrangements were in place and that everything runs seamlessly. A special thanks to our office registrar to providing excellent facility of conference hall. And lastly, in conclusion, thank you so much to all of you once again for your valuable contribution and participation. Thank you. And I am grateful to the media and thank you so much.